Hello, my name is Celeste Miller, and I'm the statewide Kinship Care Legal Aid Coordinator for Washington State. This presentation is dated February 24, 2022, and it is about the legal options for custody for kinship caregivers in Washington State. This presentation is based solely on laws in the state of Washington, and it is also general information and does not constitute legal advice. A little bit about myself. I am an attorney. I started this position in September 2019. Before I was a statewide kinship care legal aid coordinator, I was a family law attorney with my own family law solo practice. And I was very involved with a group of attorneys, the low bono section, who offer sliding scale fees and are dedicated to improving access to the legal system. I'm based in Seattle, but my job is statewide. So the legal options range from permanent to revocable for kinship caregivers, and many of them are outside of the child welfare system and don't involve the child welfare system. Others are involving the state, and those are not the focus of this presentation. This presentation was created because it's very important for kinship caregivers to know about the different legal options and be able to consider which type of legal situation is best for their needs. Speaking of the range of legal options, this is just a list for your information, starting with the legal option that is one of the most permanent and down to the one that is the very least permanent and has the least legal protection. So as you can see, adoption is up there at the top. Next is de facto parentage. After that is non-parent custody. Oh, there is a, and after that is power of attorney. Finally, informal agreement. So I apologize, there's a typo on the slide. Power of attorney is not on the same level as de facto parentage. All right, we're going to talk about every single one of those options in this video. So first up, adoption. This is a legal option that provides full parental rights to the adoptive parents. This means that if you adopt a child, you become their legal parent, and their biological parents do not have any more legal parental rights to the child. In the eyes of the law, the biological parents are not the parents anymore. Generally, adoptions are done with the help of a private attorney or a private adoption agency, and sometimes they can be done through the state with a child who was in foster care. To get an adoption finished, the birth parents must agree, so they must consent to the adoption, or they must have their parental rights terminated by the court if they didn't agree. Also, something important to note in Washington State, if you do adopt a child through the state system, as in the child was in foster care before you adopted them, and the child has special needs, the adoptive parents may be eligible for adoption support payments, and that's a monthly payment. Another thing that I hear a lot of questions about from kinship caregivers is whether they can name someone in their will who will be able to care for the child after they pass away. So if you have adopted the child, you have full parental rights and you can name a guardian in your will for your child. As we'll see through this presentation, if you are using other legal options that don't include full parental rights to you, then you don't have the right to name a guardian in your will, and there are other ways to plan ahead. For adoptions, there is a requirement for a home study. This is when a social worker or a licensed home study worker comes to your home, interviews you, writes a full report about whether it's appropriate for you to adopt the child or whether it's safe for the child to live with you. If the child is 14 or older, they also must agree to being adopted. So that is a specific aspect of Washington law that's important to note. Next up is de facto parentage. Now, this law is an interesting law. It's been in Washington state for quite a few years, and it started because of same-sex couples who did not have, where one didn't have any legal or parental rights over of a child, and then when they broke up, they wanted visitation rights or parental rights, and they needed to be able to get a court order showing that they really are the parent of the child. And de facto parentage was codified in our state statute just a couple of years ago. And so the citation to the statute is in the next slide. But what's important to know as a kinship caregiver is that de facto parentage is something that a person can file a case for in Washington state. You did not have to be a step parent or anything like that. Important to know is that unlike adoption, if you succeed in gaining de facto parentage, the parent's rights are not terminated. So the child gains a parent. So if two of their parents are still alive and well, and you get de facto parentage, then the child has 3 legal parents. Another important thing to note is that if you file for de facto parentage and you prove that you are a de facto parent and the court states that you are, that does not automatically provide you with full custody of the child. After you prove that you're a de facto parent, you must then do a parenting plan case and seek custody if you believe that you are the person who should have primary custody of the child. So it's really a 2-step process, which is important to know because I know that de facto parentage is something that's being talked about a lot in Washington in the kinship care community at this time. And at the bottom of the slide, you'll see the note about if you can name a guardian in your will. If you do have de facto parentage, you have parental rights, so you can name a guardian in your will. The other parents could as well, and then the court would determine which named guardian should be appointed if every parent of the child dies. There are 7 factors that must be proven in de facto parentage for a person to be named a de facto parent. And this list, I've slightly paraphrased these so that they can fit on the slide and not take up too much time, but the full language is in our state statute, RCW 26.26a.440, parentheses 4. So first, the child lived with the petitioner for a significant period. The petitioner consistently took care of the child. The petitioner took on full and permanent responsibilities of a parent without expecting any payment. The petitioner cared for and raised the child as if they were their own. The petitioner has a bonded and dependent parent-like relationship with the child. Another parent of the child fostered or supported the relationship between child and petitioner. And keeping the child and the petitioner's relationship going is in the best interest of the child. So you can't just show 3 or 4 of these, you have to show every single one. Next up is Title 11, minor guardianship. Now, in Washington State, this is a new law. It has only been in effect since January 2021. It replaced non-parent custody. So in 2021, the law changed over and there was some time where non-parent custody cases could be finalized, and that was between January and August 4th of 2021. After August 4th, 2021, there is no more non-parent custody cases. If you had one that was open, it is likely dismissed and cannot be finalized. So this new law, minor guardianship, replaced the old law. It grants the caregiver physical and legal custody of the child. You can have a parenting plan or residential schedule in a minor guardianship that provides visits for the parents. Unlike de facto parentage and adoption, minor guardianship does not make the caregiver a parent. So minor guardianship does not terminate the parent's rights, and it does not provide parental rights to the caregiver. It provides rights such as custody, caring and raising the child, seeing to their education, their health care, all of those things. And it does not, so the parents have a chance in the future to gain custody back of their child. What you need to prove in this type of case is that the parents are not able to perform parenting functions or not willing to perform parenting functions, and that it's in the child's best interests for the caregiver to be the guardian. Again, it's important to know that minor guardianship does not terminate the parents' rights. Parents have the right in the future to try to prove that they're able to take care of their child again. They can ask the court in the future to modify the guardianship, give them more visits and more time, or they can ask the court to end the guardianship. If you succeed in minor guardianship, you cannot name a guardian in your will for the child because, as mentioned before, you don't have legal parental rights. The parents still have those. However, a different strategy would be to prepare to request a successor guardian to take over for you in case of death or other serious reason. Another important thing to know about minor guardianship is that parents who do not agree with your request to become guardian will have the right to a lawyer that is court appointed if the parent is indigent, and that means low income enough to be eligible for a free attorney like a public defender. But in this case, it would be a minor guardianship case. Children's rights in minor guardianship are different from in the old law, non-parent custody. So in our new law, children who are 12 years old and older have quite a few rights. First, they have the right to be served the court paperwork unless the court determines that they would be harmful for the child to see. And that's something that a petitioner has to ask the court to determine. The child or children may be appointed a court-appointed attorney. It's not required, but it is allowed. If they do not have an attorney or are not appointed an attorney by the court and they are 12 or older, they will have a court visitor who is a person, not necessarily an attorney, who meets with the child, explains the child all of their rights in the case, interviews the child and the petitioner, and writes a report to the court about the child's views. So please remember that writing a report to the court about the child's views is very different from a report about what's best for the child or what's in the child's best interests, which is what a guardian ad litem does. The court visitor will say what the child thinks about the case and report it to the court. The children or the child in the case also have the right to be at the court hearing, to participate in the hearing, unless the court determines that they are not emotionally mature enough to do so. And also, the children or child can have an attorney, either one who's court appointed. If they don't have a court appointed one, they can get an attorney to represent them, maybe through a nonprofit or pro bono, or even paid if someone will pay for the attorney. Going a little more in depth about what you have to prove to become to be appointed a guardian of a child. You, aka petitioner, if you are the person seeking guardianship, you're the petitioner. You must prove that no parent is willing or able to exercise the parenting functions as defined by law. And the law this is referring to is RCW 26.09.004, and that's a family law statute that lists out what some parenting functions are. And they include the ones up here on the screen: maintaining a loving, stable relationship with the child, attending to the daily needs of the child, attending to the child's education, helping the child develop strong relationships, having appropriate judgment in terms of the child's welfare, and providing financial support for the child. So when you file one of these cases, you need evidence to show that one or both parents are not doing some of these things. Another thing that is required is to prove to the judge that the guardianship is in the best interests of the child. And finally, this information must be proved to the court with clear and convincing evidence. So it must be very convincing. In our state, the court process for minor guardianship, it will vary depending on which county you live in, but there are many general things that are the same no matter if you live in King County or Benton and Franklin County or anywhere in the state. So to file one of these cases, you must file it in Superior Court in the county where you live or where the child lives. There are a lot of court forms to complete and paperwork to submit. The court forms are available for free on courts.wa.gov under minor guardianship. And there are quite a few different things to be submitted, such as a criminal history and a background check and a CPS background check. When you file one of these cases, personal service on the parents is required. If you can't find a parent or you claim that the parent waived their right to service, the law says that a court visitor will be appointed to investigate that situation, attempt to find the parent, and report back to the court. Some counties, if the parent's name is unknown, they may require service by publication instead of a court visitor. That's just based on information that I'm hearing from people in different counties recently. In these cases, they will resolve either by agreement. So if the parents end up agreeing with the petitioner, the person who wants to become a guardian, and everyone signs off on the paperwork. Another way the case can end is by default, which is when the other parties, such as the parents, don't respond or show up to the court date after being served all the papers. And the other way that a case would be resolved is by a hearing, which is like a trial. And that would be if the parents do respond and they object to the guardianship, then there is a court hearing where each party can present evidence and explain why the judge should decide in their favor. So in King County, for example, even if everything is agreed, there is a 60-day review hearing, and the case will likely take at least 60 days to be resolved. In other counties, I'm not sure. It really varies by county if there are required review hearings or not, but generally these cases could take between 2 months to 6 months or a little longer. Another type of guardianship under our new law is called emergency guardianship. So this is a little different from the regular minor guardianship. It is short term. It's only 60 days, but it can be extended once. And the reason for emergency guardianship is so that a petitioner can go to court when a child's safety is at risk and ask for emergency guardianship to happen sooner than a regular guardianship would happen. Like, as I was just saying, a regular minor guardianship is unlikely to be finished until at least 2 months have gone by. So an emergency guardianship, it is possible to get an immediate temporary order the same day that you file a request for emergency guardianship, if you have enough evidence showing that the child is at risk and it's very serious. This type of case has slightly different paperwork for minor guardianship. However, the state legislature is helping us by allowing us to combine the cases going forward. And the law will change as of winter 2022, which is exciting. And in emergency guardianship, what you have to do is show the judge that there is no other person who is willing or has the authority to take care of the child, and that or ability to take care of the child. That's in the amended version of the law as of February 2022. So you have to show that no one is able to take care of the child or is willing to take care of the child, and that if you are not appointed as an emergency guardian, the child could be in serious danger. As I said, these are short term, but they can be extended. You could also file an emergency guardianship when the law is enacted, that is being changed this month in February. You will be able to file both at the same time, and you could have an emergency guardianship while you are trying to get a regular guardianship. Now, I mentioned earlier that our state law on non-parent custody was repealed and replaced by minor guardianship. So I just want to address what happens if someone has a non-parent custody and had it before 2021. So if you have non-parent custody and you've had it, before 2021, or it was finalized in 2021 before August 4th, then your non-parent custody order is still valid. It does not go away. You do not lose custody of the children. The only way to modify or terminate the non-parent custody order from before is by the court to change it, either based on you and the parent's agreement, or based on if a parent files to modify or terminate it and proves in court that the reason that they lost custody originally is no longer a problem. One way to check about this is to look at your non-parent custody order, see if it says anything like final or temporary on the first page. If it's a temporary order, and you don't have a final order, it's likely that your case, that it's not valid anymore. So it's very important that it be a final non-parent custody order for it to be valid. Another type of guardianship that I won't spend too much time on, but is in our new law, is called standby guardianship. So this is the type of guardianship where parents and the proposed guardian work together. If the parent knows that something could happen to them, like they've been diagnosed with a serious illness, or they're concerned about maybe being deported, they can nominate someone as a standby guardian, and they do that by filling out specific paperwork. If you are nominated as a standby guardian, you don't automatically become a guardian. Basically, after you are nominated, you wait until the potential future event looks like it might be happening. And then you or the parent would file a case in court to appoint whoever was nominated to become the guardian now, because the parent health is getting worse, or something happened where you no longer should be on standby and you should become the guardian. Now, coming down to a non-court involved type of custody is the power of attorney for custody. So this is also in our new law, the Title 11 Uniform Guardianship Act. This created a new type of power of attorney that includes custody, like physical custody of a child, which in Washington State's other power of attorney statutes, custody was never explicitly stated. So this is new, and it requires agreement by the parents, because it's the parent who can grant the power of attorney for custody to you. So they would fill out a form, and it needs to be notarized or have 2 witnesses sign it. Power of attorney for custody is helpful when you and the parents are agreeing and planning things together. That's because if the parent changes their mind, they can take it back at any time. They don't have to write it down. They don't have to tell you in writing that they're taking it back, but they do need to tell you. This type of power of attorney can last up to 24 months, but it can be 6 months or 10 months or whatever amount of time the parent puts in the form. It also can provide some powers and not all powers. There is an example form on Washington Law Help. So the parent can either mark off every single type of parental power, like medical, permission for medical care, planning for education, taking the child out of state or out of the country, or they can check some and not check others. This, like I said, this is the type of agreement that can be really valuable when you're working together with the parents. If you're concerned that the parents will revoke the power of attorney, you may need to look into the different court processes like guardianship. Lastly, I have information about unwritten agreement, which basically is something that I know and you all know happens quite often actually with kinship caregivers. It's when a child is living with you because the parents brought them to you or lived with you also and then left. And there's nothing in writing, there's no power of attorney, there's no court orders of guardianship, and you're just doing what you need to do and taking care of the child. So even if there's nothing in writing and there's no court orders, there are some important laws for you to know about. For example, there's a law called the McKinney-Vento Act that should help you be able to enroll the child in school and be the school's person, the contact person for the child. This is a federal law that basically includes children who aren't living with their parents under a large umbrella of children who have specific rights, including, who the school should talk to if they aren't living with their parents. Another Washington law that's important to know is about consent to medical care. If you are a relative of the child and you tell and you represent to their healthcare provider that you are the person who is in charge of consenting to their health care because you're caring for them, and or you sign an affidavit stating the same, the medical provider should accept that. The statute is RCW 7.70.065 for your information, because that's something that I have heard kinship caregivers will even show the statute to the medical provider and they may not have known about it, but it is there, and it's for you, if you are a relative, to be able to get the child the health care that they need. And then there is also the option, even if you don't have any, court paperwork or power of attorney, there is still the option to apply for benefits for the child, such as child-only TANF, and that's based on the child's income. So child-only TANF is a financial benefit that kinship caregivers can receive, and it should not matter how much the kinship caregiver makes in their job, because it's based on the child's income. So this is something that's really helpful to kinship caregivers, to provide extra money each month to help care for the child and feed them and all of those things. And it's something that should definitely be taken advantage of. Thank you very much for watching. This is a recorded version of a training that I do quarterly in King County, but this one is open to anyone in the state of Washington, especially kinship caregivers, to watch and learn about the different types of laws that could potentially be helpful in your situation. Thank you very much, and have a great day.